Welcome back, everybody. Your midterms are here. Wait till the end of the class, pick them up. I'll stop early, give you plenty of time so there's no mash. And anybody who musses up my neatly alphabetical stacks is in big trouble. Well, we're in the home stretch. Your paper's due a week from today. Any questions about what to do on it? Rob? As long as you cover all the bases, I suppose so. I mean, I'm not immune to humor, but you got to cover all the bases. I mean, really do pay attention to the prompt. Mm-hmm. No, you would just, well, I mean, if you can get inside their head and reveal to all of us what they were thinking, that's wonderful, but I don't expect that, no. Okay, well, let's switch gears here. Instead of thinking of the First Amendment as a shield to fend off punishment or liability for something that you say, let's consider an issue that came up for the first time in the early 70s about whether the First Amendment can be used as a sword, particularly by the press, to get what it needs to do its job. In the early 70s, just around Watergate and post-Watergate, investigative reporting became much more of a phenomenon where reporters, instead of taking press releases from the White House and putting their own name on it, or attending open meetings and reporting what happened there, started to dig for information that the government didn't necessarily want to give up, and found that the government was not terribly cooperative in that. So the question became, does the press and the public have a First Amendment right of access to information? And the first issue that this came up with was access to places. The general rule for reporters was the same rule that applies to all of us, that we don't have the right to go on somebody's private property, somebody else's property. That would be trespass without their consent. And reporters have to comply with laws of general application that all the rest of us do. So just because they're pursuing a hot story doesn't give them the right to go someplace where the general public doesn't have a right to go. The press, of course, argues that their special needs to gather information, to report to all of us so that we can participate meaningfully in a democratic society, requires the press to have some leeway, some freedom that maybe members of the public don't have. And that raises the question of press exceptionalism. Should the press be treated differently under the First Amendment than the rest of us citizens? That's an issue that we'll take up next Tuesday when we consider whether those four words in the First Amendment or of the press add anything to the freedom of speech that we all enjoy. The issue of access to places came up first in a difficult environment, that is access to prisons, which traditionally, of course, have been closed institutions, not open to the press or public. And the first cases that the Supreme Court, actually one opinion, Supreme Court considered on this issue were the Pell and the Saxby decisions in 1974, which we touched on when we talked about Danny Martin, the convict author. Pell and Saxby involved, Pell was a state case. It was Pell versus Procunier, the director of the California Department of Prisons. Pell was Eve Pell, who was an investigative reporter. And they challenged a state Department of Corrections rule that prohibited the press from singling out individual prisoners for interviews. The problem, as you may recall from the Danny Martin discussion, was that the prison officials thought that there were some prisoners who were becoming celebrities because they commanded media attention and were able to develop their own kind of power base within the prison and challenge the prison authorities, and it made life difficult for the prison officials to keep a tight lid on security if individual celebrity prisoners were able to talk to the media and get their story out there. The federal prisons had the same rule that they adopted about the same time as California did, a rule that simply prohibited the press from calling up the prisoner and saying, hey, I would like to speak to George Jackson, for example, celebrity prisoner that Eve Pell wanted to interview. Jackson was accused of murder. He was one of the Soledad brothers accused of killing a guard down at Soledad prison, was transferred up to San Quentin, held in maximum security, and he was a charismatic prisoner, a real leader, a leader of prisoners, a leader of anybody. He was articulate, he was political, he was savvy, and he was trouble for the prison officials, and they didn't want him to be any more famous than he was, so they enacted this no-interview rule, which was challenged by Eve Pell in federal court in California. In the federal prison system, the Attorney General was William Saxby. That was one of Nixon's Attorneys General. The Washington Post had been paying attention to prisons, and they challenged the federal rule. And both cases landed in the Supreme Court, decided in 1974, 5-4, Justice Potter Stewart writing the majority opinion that upheld the rules against First Amendment challenge. And Stewart's opinion pointed out that there was no attempt through these rules to conceal conditions in the prisons. Reporters were allowed to come into prisons. They had to call up and make an appointment, but they could come in. They could bring their cameras, television cameras, still cameras, take pictures of what was going on. They could interview randomly encountered prisoners, but they couldn't single out individual prisoners for interviews. So access was pretty good, Stewart pointed out, but there was some justification in terms of the big wheel theory that the prison officials operated under for prohibiting individual prisoner interviews. Surprisingly, Justice Lewis Powell, a Nixon appointee, dissented in the Pell and Saxby cases, saying that this rule is too crude an instrument for use in a First Amendment thing. You can't use a blunderbuss when a scalpel is required, and you can't prohibit across the board all individual interviews. You ought to be required to discriminate, and if the prison officials could point to a particular security problem caused by a particular proposed interview, then they could prohibit that, but they can't prohibit all interviews. And his theory was that while it's probably true that the public can't go trooping around in prisons to find out what's going on there, the press acts as an agent for the public at large, as the eyes and ears of the public at large, and they ought to be allowed to get in and report to the public what's going on there. There were a couple of ambiguities in Stewart's opinion. that made it unclear exactly what the court had decided. First, did the case turn on the fact that there was pretty good access by the press to prisons, or that there's no constitutional right of access at all? And second, is the problem that the court thought it was dealing with is that the press demanded some kind of special access not available to the general public? Or, on the other hand, was it that neither the press nor the public had any First Amendment right of access? And Justice Stewart said in his opinion that the press has no greater access to information than the public generally. Well, less than a year after the Pell and Saxby decisions, I got a call from Mel Wax, who was the news director at Channel 9, KQED in San Francisco, and he had just gotten off the phone with the sheriff of Alameda County, Tom Houchins, and KQED had then had a daily news program, and they were following events at the Santa Rita jail, the Alameda County jail out at Santa Rita, the old jail. And there had been, the conditions there were horrible. A federal judge had condemned the conditions as cruel and unusual punishment a couple of years before, and in the maximum security or Greystone part of the heart of the jail, the conditions were exceptionally harsh, and a psychiatrist came on the news program and said that a prisoner had committed suicide there that week that the psychiatrist was on the air, and that conditions in that part of the jail were driving prisoners crazy. So Mel Wax had called up the sheriff and said, we'd like to send a reporter and a camera person out to the jail, and can we make an appointment to do that? And the sheriff's response was, no way. My policy about access to my jail is that there isn't any by press or public, that reporters are not allowed in at any time of the day or night for any purpose. And Wax asked me, can they do that? And I, of course, was familiar with Pell and Saxby, remembered that access there was pretty good, and it seemed quite unreasonable for a government official to be able to say to the press, you can't come in here, even if there's no problem whatever with jail security. So Wax decided that we should file suit. We filed suit in federal court in San Francisco. And as soon as we filed suit, the sheriff initiated a series of monthly public tours of the jail. The first one was scheduled inadvertently, I'm sure, for July the 14th, 1975, Bastille Day. And they were all sold out. There were 25 people allowed to go on the tours. They were all oversubscribed the week they were announced for the balance of that year. And the tours were a little sort of architectural because you didn't get to see any prisoners. They hustled all the prisoners out of sight. There was no way to interview any prisoners, talk to any prisoners. And you could look at the buildings that they were in. The tour did not include the little Greystone maximum security part of the prison at all. But the sheriff's defense to our lawsuit was that he's giving the press and public precisely equal access to the prisons. And under Pell and Saxby, that's all he's required to do, the tours. In putting together the lawsuit, having been educated by Pell and Saxby, I decided that we ought to have a party in there who is representative of the general public. That we're not claiming exceptionalism for the press, but the general public too cares about this. So we joined as plaintiffs to the Alameda County and the Oakland chapter of the NAACP, citizens who paid taxes for their county jail and wanted to be informed by the press of what was going on there. As you read in the book, that was a fateful decision that backfired on me, but not until the case got to the Supreme Court. We had a two-day hearing before Judge Oliver Carter in San Francisco and testimony about whether there was any jail security problem with press access. There wasn't. And so the judge issued a preliminary injunction requiring the sheriff to allow KQED and responsible members of the press access to the jail at reasonable times, and the sheriff would be allowed to shut down access if there was some genuine security problem with access at any particular time. It seemed like a fairly reasonable order, but the sheriff appealed to the Ninth Circuit, and the appeal was expedited so that we weren't excluded from the jail for too long. Hadn't been in yet. And the three judges on the Court of Appeals agreed that KQED had a First Amendment right to access to the jail, but they couldn't, any of the three of them, agree on a theory for why that was so. And they were baffled by the ambiguities left in Stewart's, Pell and Saxby opinion, and they were baffled by how to characterize the First Amendment right of access to a jail. And perhaps because they were badly split, the sheriff took the case to the Supreme Court. Justice Rehnquist issued a stay so that we still were not allowed in the jail, and the case went to the Supreme Court. And the court was shorthanded for the argument because two justices recused themselves. Justice Thurgood Marshall recused himself because he had been general counsel for the NAACP back in the 1930s and the 1940s, and he routinely took himself out of cases in which there were NAACP parties. I don't think that was at all necessary, but he always did it. And so my strategic decision to include the two chapters of the NAACP lost a crucial vote in the Supreme Court. And Justice Harry Blackmun didn't participate in the case because he had just had prostate surgery, and so we're looking at a 7-justice court. And in my idiosyncratic ranking of First Amendment sensitivity, on the right wing, it had Chief Justice Berger, who this is old material for you now. You know Justice Berger's views. He didn't like the press at all. He was no First Amendment guy. Here's what the court looked like in those days. Pardon the megaphone over the face of one of the justices. Rehnquist, of course, was very conservative and not a First Amendment. White was a Democrat, but an appointee of Justice Kennedy, but he wasn't friendly to the press, as we've seen in other cases. The man in the middle, as always, was Justice Potter Stewart, the nominal Republican, the author of Pell versus Saxby, interested in the press, thoughtful about the rights of the press, interested in the First Amendment, but certainly not a doctrinaire First Amendment absolutist of the kind we encountered with Black and Douglas and so on. But he's the one who had to be convinced. The new on the court was Justice John Paul Stevens, who was President Ford's only appointee to the Supreme Court. He had no track record in the court. He was new. But he had served on the Seventh Circuit Court of Appeals in Chicago and had there exhibited some sensitivity, at least some civil liberties sensitivity, and he was skeptical about prison officials' justifications for denying prisoner rights. So he might be hopeful. And then you had Justice Lewis Powell, who, a Nixon appointee, wouldn't normally consider him a strong First Amendment vote, but he had authored the dissent in Pell versus Saxby. So, gee, maybe we can get Powell. And then Justice William Brennan, the stalwart supporter of the First Amendment, you had to hope that he would come along. The case was argued in the Supreme Court by Kelvin Booty, who was a career county counsel in Alameda County representing the sheriff. And it was his first argument there, and he was kind of nervous, and it takes him a while to get his papers together. I've edited the argument down to bare bones, but bear with me while I get what Booty had to say up and running.
Options against station KQED.
That's Berger calling the case, and then Booty gets up and shuffles his papers, trying to figure out what he's going to begin with.
Mr. Booty, you may proceed when you're ready.
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court. The question presented in this case is, must the sheriff give greater access to his county jail facility to the media than he gives to the public? The purpose of the access in this case is to gather information. The district court in this case required that certain access be given to the media. There was no requirement that similar access be given to the public, and there was no determination by the district court that the public access was inadequate in any way. The required media access is, as I say, greater than the sheriff gives to the public. I'd like to discuss briefly with the Court what that public access is. First of all, it is mail, access by mail. There's no censorship. Letters are not read. They are subject to inspection only.
Mr. Lee, can I interrupt with one question? Isn't the first question whether there was a violation of law that entitled any remedy, which requires an examination of the situation at the time the lawsuit was brought? Shouldn't you tell us what kind of access there was when the proceeding started?
Yes, Your Honor. All of the accesses that I'm discussing, except for the public tours, had in fact started when the proceeding started. So I will answer Your Honor's question in that way. The mail was there at the time the proceeding started. As I say, it was, if the inmate lacked cash to pay for stamps or postage or anything like that, that was provided. Secondly, at the time the proceeding started and after, there is visiting, ample visiting. It's unquestioned example. There's no categories of persons who may visit. They need not be members of the family or anything else. Anyone, including a reporter, would visit. There are some restrictions on those who have been in prison or those who are under 18. The prison restriction stems from provisions in the California Penal Code. Again, at the time the proceeding started, there was access by telephones. For those who were in the maximum security facility, there was telephone access on a collect basis to anyone. The phone lines did not go through the sheriff's department in any way. They went right to the telephone company. So there was no monitoring, no capacity for us to find out who was called, what was said, nothing. Totally open telephones. Other than in the maximum security facility, telephone access was through the correctional services officers. Again, Mr. Justice Stevens, at the time the proceeding started, there were interviews with pretrial detainees available. Those could be done, in fact, they would have been done typically off the premises. Those could have been photographed, tape recorded. They would be private. No one from the sheriff's department would be there. The requirement there is that consent previously be obtained from the inmate himself, from his counsel, from the district attorney, and from the court having jurisdiction over the trial. What was not present at the time the proceedings commenced were the tours.
What he's doing here is what government frequently does in First Amendment cases. When you say, I need to communicate this, I want to say that, I want to go here, the government says, well, our restriction is very narrowly targeted at what you particularly want to do, but there are alternative means of communication. You can get your message across to the public. You just have to use some alternative channel, not the one that you simply prefer. It's the same reasoning that we encountered in time, place, and manner restrictions in the demonstration context. And Booty's saying, well, look, they can visit prisoners, if they know any, and if they can wait till Sunday for the visiting period, prisoners can send mail, uncensored mail out to lawyers. They can make telephone calls from the jail. Those alternative means of communication mean that you shouldn't worry very much about the restriction on the press being able to get in. Then Powell asks a question. He has a very soft voice. It's hard to hear, but he's inquiring about the public tours.
On the briefs of the record, say opinion that they were.
They became, the first 6 months of the tours became booked very quickly, quite possibly before the end of July. The first tour was on July 14, 1975, and probably before I don't remember. My recollection, Your Honor, is that before the end of July the tours had been booked.
And so if there were some occurrence in the jail that might have been of public interest, there would be no way for a representative of the media to get into the jail unless he'd been signed up several weeks in advance?
That's correct. He could not have gone on one of the tours. That, of course, is not the only means of access, Your Honor. Had there been an occurrence in the jail, indeed before the tours ever started, the media can and does have alternate means of finding out what's going on by means of interviews. I have not completed the access that is now was then available to the media.
Booty, you've been outlining what I gather are general policy.
This is Rehnquist, who's asking, as a way of communicating to the other justices on the court, that they speak through questions to the advocates, but they're really talking to their brethren on the court. And Rehnquist asks,